Hélène, this use of a trans-border but subnational agreement is not unprecedented. And my experience has been in water, and especially the Great Lakes Charter and the annex to the Great Lakes Charter, which has similarities, although it had teeth in the United States because the basin states are bound by an interstate compact, which has real legal force in the United States. But the trans-border agreement is, as with this one, ultimately non-binding. But I'm more interested in how it came about. In the case of the Great Lakes Charter, it was a combination of interested provinces, certainly, but also very active non-governmental organizations, especially Great Lakes United, which was a trans-border environmental organization. And federal governments, both Canada and the United States, that basically just facilitated. They stepped back and let the provinces and states work it out. And I wonder if you could comment on how this agreement developed. Was it something that was facilitated by the federal governments, or is it just something that the states did on their own, or?
Well, I'm not sure how it. There it is. I don't think it was facilitated in any way. You mean that specific agreement?
Yeah.
Not the charter. No, I don't think it was facilitated. From what I understand, it was the Harper government at that moment, and there was no help, I don't think so, by the federal government to conclude this. It's really like an agreement between the executive of the province and the state of California. So it's quite interesting, actually, because it does not involve the two federal government in that specific area. So, but I cannot answer in more details to your question, because it was possible that there was some kind of discussions, of course, between the executive of the some people at the federal departments, for instance. But I think it was in a context where, Quebec government wanted to do something. They had their target fixed, and there was California, and they were already working with California within the WCCI. And it came down to that, I guess. It was like negotiated between the two entities.
Can I just have a quick follow-up to that? We've seen that you can withdraw from these agreements very easily, and we saw what happened with the Ontario election. I'm not too sure what the new government of Quebec, what its position is, or if it's taken one on this.
That's not clear at the moment. I don't think there's any like specific statement that was made on that. I hope it will continue. I guess there's no real. I guess the new government will take time to probably examine the situation. I don't know if Paul, you know a bit more about that, or. Yeah. So we don't know, but I would suspect that it would, it will still go on. It's like it took years to put in place, and it would be, I guess, really disappointing for many people to. So it works, and I guess it would go on. I hope so, actually.
Thank you very much for your presentation. My question relates to a concept you explained of delocalization, and I was wondering how the federal carbon approach and what it's trying to achieve, and then the Quebec trading cap and trade system and the idea of delocalization kind of work together, because it would seem to me that just from what I understood from your description that they're kind of at odds. You could achieve reductions in another jurisdiction, but but make up for it with credits, whereas the federal approach is trying to achieve the reductions in a particular jurisdiction. So.
Yeah, well, actually, that's a very good question, but I'm afraid I don't have an answer for that, because of course, we see it right away. You know that it might be those are different systems, and even the idea of a taxation, the pricing of carbon is very different whether you experience it through like a cap and trade system, and like a tax system, for instance, or so. I don't know. For me, I mean, I see it like I'm not sure we will be able to put it's not the same. It's not the same regime. It doesn't work the same way. So, and of course, what is important when you have a cap and trade system is to globally have the reduction. And as long as you globally have the reduction that were fixed and the target, then it works. You know, so it doesn't matter where you do the reduction as long as it is within the. It's as if now it's as if the air over California and the air over like Quebec is a bit linked in a way, and it's a global environment in a way, and so the reductions that are being made in California are as good as the ones made in Quebec, and globally they do. It reduces the pollution and it reduces the emission of greenhouse gases. But for the linkage with with the federal system, and of course it's not the same. So I'm not sure how it will be dealt with. Maybe Madame Vachon would have answer to that, because I don't know what's in the negotiation with that. But for me, I think the Quebec government did what it could to attain some objectives, and its own objective is like 20% for 2020, based on 1990, which is like more than what was done at the federal level or in the other provinces. So that would probably be put into the equation. Yeah.
Bonjour, mon nom est Jean-Pierre Bergeron. Tout à fait fortuitement, je me présente ici aujourd'hui. Je suis avocat à la retraite, mais assez étonnamment, je ne connaissais pas l'ensemble des présentations qui allaient être livrées aujourd'hui. Je suis un des rédacteurs de l'entente Californie-Québec. Alors, je peux vous parler un petit peu de la substance, de comment c'est arrivé. Je vais livrer mes commentaires en anglais et en français. To answer your question as to how the Quebec-California agreement arrived, basically, Premier Charest was one of the main, was the main impetus, excusez le lapsus, in the WCI. So the marching orders were to go forward with any jurisdiction that was interested in agreeing on a cap and trade system. Well, we wrote, I negotiated and wrote with, not solely obviously, but when you see the articles that were projected on the screen, 15 and 17, I sort of recognized the handwriting that I had done at the time. So the origin of the cap and trade agreement was because other actors decided not to follow suit. So basically, California and Quebec were the only two actors left. There was the RGGI, there was a Western Climate Initiative, where New Mexico and other states did not decide to pursue the impetus that Jean Charest wanted to give to the cap and trade agreement. So a few things that maybe I could point out, I think, in the commentaries that are made both by Professor Wright and Professor Trudeau. Je vais traduire. La question de l'observation de la loi. Pourquoi c'est dans un langage si flou? Entre autres, en termes d'autorité qui devait voir à l'administration de la loi. D'abord, il il y avait les ministères respectifs, le CARB en Californie, puis le ministère de l'Environnement au Québec, qui avait une dimension d'observation de la loi à assurer. Mais s'il y avait des crimes, fraude, quelle était l'organisation qui, de part et d'autre de la frontière, pouvait assumer la responsabilité? Au Québec, est-ce que c'était une tâche qui allait être confiée au ministère de l'Environnement? Est-ce que c'était une tâche qui allait être conférée, par exemple, à la Sûreté du Québec? Et la même chose en Californie. Dans la présentation, il était question d'observation, de transparence. Une dimension particulière de la transparence existe nettement aux États-Unis, où avant de signer l'entente, avant d'adopter la réglementation, le CARB est tenu à une obligation de démontrer, avant que ce soit adopté, ce que ce sera. Au Québec, on n'a pas le même régime juridique, de sorte que forcément, ça se fait par une certaine publicité de registre, comme le tableau qui a été montré. Il y a évidemment les lois d'accès, mais ça, on l'a retrouvé dans la rédaction de l'article 17, je pense, qui a été affiché au tableau. J'aurais une précision, je pense, dans la présentation du professeur Wright, quand il parle de pénalités jusqu'à concurrence de 500 000 $, d'après moi, ce sont des amendes. C'est accompagné possiblement d'emprisonnement. Ça variait en Ontario puis au Québec. Et ça ne serait pas, à mon sens, à l'exclusion des pénalités pécuniaires administratives qui pourraient peut-être, dans certaines circonstances, être appliquées. Alors, voilà quelques précisions.
Bien, merci beaucoup. Je ne savais pas qu'on avait dans la salle le rédacteur de l'entente, ou en tout cas un des rédacteurs. Oui, c'est ça, c'est une bonne source. Oui, bien, merci beaucoup. Je pense que ça clarifie le contexte dans lequel ça a été fait. Et puis,
I wonder, we've just had a few people have mentioned this, including yourself, this contribution, also Professor Wright. The original plan seemed to be a much larger group, and it disappeared pretty quickly. And I wonder, no one I think has actually talked about why it fell apart. Was it just a lack of political will, a preference for carbon taxes perhaps that made it less interesting, or?
well, I don't really know. I mean, it's obviously linked to the fact that you see all the changes that happen every time, like there is a change of government in the provinces. So probably the political, the situation of each province and state that were in the initial, of course. Well, some of them were just observers. I mean, it was quite loose as as a structure at the beginning. So it just turned out that Quebec and California were the ones, because the prime minister is here in Quebec, and I guess there was like a will to go on with that, and so the structure was there initially, and it's still there. But someone mentioned that Nova Scotia just joined. So I heard about it, but I was not able to document it. But I know that Nova Scotia might be like the next partner, and the next partner to put actually a cap and trade system. So it's quite volatile in a way, I guess, that kind of, but still it was the WCI was, I mean, there was like a real structure that was suggested to the government to put in place there, how to, what the statute should contain as a minimum, to be able to join after that the cap and trade system. So there was some work done by the WCI. So it's even though. And there were more, like, some of the actors were still there at the moment when there was that kind of negotiation. It's just that some governments, so some provinces, and decided to go on with a tax instead of a cap and trade system, and decided to, to go on with some other way to, or to delay for, later the actual. So it's mainly political, I would say. Yeah.
Maybe this is something we'll wait for the U.S. midterms, which are also electing governors. So, Jonathan, did you want to?
Professor Trudeau, thank you. I'm John Leo. I'm from the U.S. I'm speaking tomorrow, and it seemed like an appropriate time to mention this because I made a remark in my own paper for tomorrow about ways that states are constrained in the United States by the U.S. Constitution and by ways in which the U.S. Supreme Court has interpreted federal law to prohibit states from taking certain kinds of actions that the federal government, from time to time, as the political winds blow in different directions, may not like. And I was even unaware, until I did some research, of this particular clause in the United States Constitution, so it goes back to 1787. No state shall, without the consent of Congress, enter into any agreement or compact with any state or with any foreign power, period. So my sense is, and Professor Saunders, I'm not sure, I know about the Great Lakes Compact. I don't know that it exists. I don't know the details of it. I don't know whether or not Congress, the U.S. Congress, explicitly authorized that compact, or whether there was some understanding that the U.S. government would not object to it. I don't know that the U.S. government has ever, neither the George W. Bush or Obama, certainly not the Trump administration yet, objected to the California-Quebec agreement. My sense is that when it comes to climate change and environmental matters, the U.S. government knows that it better not take on the state of California because it's in for a lot of trouble if it tries. There is a battle going on right now between Trump and Jerry Brown, the governor of California, about giving California a waiver from vehicle emission standards, federal vehicle emission standards. That's getting very hot. My sense is, though, that even though there is this clause in the U.S. Constitution, that the federal government is simply choosing not to get in the way of these because it does not regard these either transnational sub-sovereign agreements or even compacts among states as threatening U.S. commerce or business interests. At least that's my perspective.
Interesting.
Yes, I'm aware of that clause in the Constitution, and briefly, the United States Congress has never approved a compact between a state and a foreign government. Of course, it does approve interstate compacts, which are the source of interstate compacts is basically that clause. And the Great Lakes is interesting because the Trans-Border Agreement is indeed non-binding, although it's been effective because both Ontario and Quebec have legislated it, so it has legal effect domestically. Within the United States, the identical agreement, which they signed across the border, is reflected in an interstate compact, which is binding on the basin states as a matter of U.S. constitutional law. So it's an interesting hybrid. There are really two agreements with differential legal effects. And I should say that there are hundreds and hundreds of these state province agreements, which is why we're allowed to drive in the United States, because we have reciprocal agreements with our driver's license for every U.S. province, U.S. state and Canadian province. So that's just a short comment. We're exactly on time, so thank you very much to Professor Trudeau and also to our phantom professor in Calgary, and we'll see you back here at 3:30.